Bismillah ar-Rahman ar-Rahim wa salatu wa salam ala ashrafil mursaleen sallallahu alayhi wa sallam. We are going to resume and convene with our lecture about commercial law for business students for Al Isra University students, and started on page 184 and talk about the registered company. Definition of the company. We have to define the company first of all. One definition of a company is that it is an association of members, be owners, whose shares in the property of the company are transferred from one to another by sale. Another way of defining it is the company, an association of individuals for purposes of profit, possessing a common capital contributed by the members composing it, such capital being commonly divided into shares of which each member possesses at least one, and which are transferable by the owner. This is a corporation created in compliance with the registration procedures in the Companies Act and monitored by the company's registry. The purposes of the registration process: to check that before it starts trading, a business is financially viable, has a reasonable chance of success, and is likely to be reputably managed for legal purposes. To provide a public record for all such businesses, which may be inspected by interested parties before trading with or investing in them. Third, to guard against fraud. Fourth, to enable continuing supervision of the company by the company's registrar. A registered company is generally required to provide a regular update of the information required on registration. Classes of companies. In practice, all companies fall into three basic legal categories. Number one, unlimited companies. Unlimited companies, there are personal-wise sort of companies that depend mainly on the partner personality. It does not call for a great deal of discussion. Note that the word limited is not used as the last word in the name of the company, and that is liability of the members is unlimited. An unlimited company may be registered as a limited company. Companies limited by guarantee. Companies limited by guarantee. A company limited by guarantee is a private company which has the liability of its members limited by the memorandum of association to such amount as the members may respectively thereby guarantee to contribute to the assets of the company in the event of its being wound up. Leading examples are trade associations and organizations formed to promote charity, education, science, etc. They do not normally have a share capital, as they are not formed for profit, but they acquire the benefits of incorporation by registration. The third kind of companies limited by shares. companies limited by shares. This category is by far the most common, and it represents the ordinary limited company of modern commerce and industry. In a company limited by shares, the shareholders can only be called on at many times to pay the company the amount unpaid on their shares. This liability is stated in the memorandum, and once the shares are fully paid up, it ceases. Under the Act, companies limited by shares are classified as either public or private. Public companies or private companies. Public limited company. Public limited company. A public limited company, PLC, is defined by the Act of a limited company, whether by shares or by guarantee with a share capital, whose memorandum states that it is a public company and which has registered as a public company and must identify itself on business stationery, etc., as public limited company. A public company will only be registered as such if it has at least 250,000 Jordanian dinar (GD) of authorized share capital. It is called a public company because its shares may be transferred freely to members of the public, other than the one who founded it. If the company is listed, the shares may be traded on the stock exchange. This enables capital to be raised easily. An applicant for listing must satisfy the requirements of the law. In practice, only large public companies will be eligible. Most of the members of a public company will aim to share in its profits without taking any part in its management. Private limited company. Private limited company. A private limited company or a private company is known by the law as any company that is not a public company. The minimum number of persons who may form a public company is two. For private companies, there is now no restriction on the number of members or shareholders, but some laws restrict the parties by some number, like 50 shareholders. Note, the companies limited by shares are often known generally as joint stock companies. Any registered company which is not a public company is a private company. It must have limited Ltd initials after its name. This is the type of company usually formed by a sole trader or a partnership seeking the advantages like limited liability which incorporation may bring. Since the implementation of the company's single-member private limited companies regulations, a private company may be formed with only one member and has dispensed with the requirement for a company secretary. Shareholding in a private company is usually limited to participants in the business and sometimes their families. Most, if not all, of the shareholders may be engaged in managing the business. So, such companies are sometimes described as quasi-partnership. The transfer of the shares will be controlled by the company rules. If a member leaves her or he or she may have to sell back his or her shares to existing members of the company or obtain the company's permission before selling them to a third party. A private company may later re-register as a public company if it is grows to the point where this is appropriate. The new legislation aims to remove unnecessary bureaucracy and to lessen the administrative burdens of small businesses. The process of registration has not changed, but a private company may choose by an anonymous vote of its members to opt out of certain obligations like holding an annual general meeting or appointing auditors. This is clearly a sensible choice for a company incorporating a previous partnership of 3 or 4 people.